With every new year, we bring a whole new set of laws. Yes, the government is always piling on new laws every new year, especially in places like my former home state, the Socialist Republic of California. It seems like every year in California, they have about 800 to 900 new laws. I don't know the number for this year. I just don't want to think about it. But it's so interesting how the government rarely repeals any laws. They just keep making new laws. And when I was a kid, my mom used to say to me, Jason, ignorance of the law is no excuse. And I think that's a very legit thing to say. The problem is there are so many laws nowadays. How can one not be ignorant of all of these laws? Listen to the interview I did years ago with the author of a book called 3 Felonies a Day. And basically, he just goes through all of these laws that we're all breaking and we don't even know it. And the dangerous thing for liberty about this kind of situation with government, the dangerous thing is that they always have something on you, right? The government always has something that they can get you for if they want to. So everybody becomes a target, and it's really scary. Well, one of the big new laws that a lot of people have asked me about, and I got some requests to do an episode on this, so here we go. That is the law that went into effect January 1st of 2024. It is none other than the Corporate Transparency Act. And you might be thinking, Jason, well, what does this have to do with me? I'm just a real estate investor. I want to buy a couple of rental properties. But if you're smart, you've set up a structure. You've got LLCs, maybe corporations, maybe trust. And in doing this, you now have an additional requirement. But look, it's not that big a deal. So don't panic. We're going to go over it today and help you with that. By the way, one interesting wrinkle about this is that if you formed your entities before January 1st of 2024, you are exempt for 1 year. You have a 1-year extension on compliance. But if you form any new entities after January 1st, 2024, you've got to comply right away. So this is a hassle. It's going to be probably an additional expense. One of the lawyers we work with is offering to do this for $200 per entity. My understanding is once it's done, you don't have to think about it again. It's done. It's not like you have to do it every year or anything like that. I suppose if the ownership or the direction of the company changes, maybe you have to do it again. I do not know the answer. I do want to always make the disclaimer, I'm not a lawyer. I'm not a tax advisor. Consult the appropriate professionals on everything. But look, we're going to go to the source in this episode today, and we're going to look at a couple of videos from none other than our friends at the government. Okay, so let's go ahead and do that. So first of all, let's go to none other than Secretary Janet Yellen and see what she says. Remember, she was the former chair of the Federal Reserve, and now she's in the Treasury. What do you know?
For too long, criminals have hidden behind anonymous shell companies to launder the proceeds of illicit activities like corruption and human trafficking through the U.S. economy. This dirty money flowing in from all over the world undermines fair business competition and poses risks to our country's economic and national security. But thanks to the new beneficial ownership framework, we're making tremendous progress towards changing this. From January 2024, many companies doing business in the United States will begin to safely and securely report.
Just wait till you see who they've exempted from this. You're going to love it.
And controls them, leading to much needed transparency.
It's not you. Just
to everyone who's involved in this work, thank you for contributing to strengthening our country's financial system.
Okay, so obviously the idea behind this, or at least the stated purpose, is to make sure they can control money laundering from drug dealers and terrorists and so forth. So let's go into the details of this. And this really drills down on some details. I'm going to have some commentary, but there are, I think, 23 exemptions to the Corporate Transparency Act. Wait till you hear who they've exempted. What a surprise. As Gomer Pyle would say, surprise, surprise, surprise. Some of you don't even know the reference there, but I'm going to speed this up, by the way, so it's not so boring.
I'm Brian Nelson, the Undersecretary for Terrorism and Financial Intelligence at the U.S. Treasury Department. Thanks for joining me for this quick overview of beneficial ownership information reporting requirements, why they matter, and how they might apply to you. For years, criminals have laundered enormous sums of money into the United States with anonymity. Anonymous companies destabilize our local economies, harming fair business competition on main streets across America. They compromise our national security, and they enable crimes like drug trafficking and terrorism. Starting January 1, 2024, with the implementation of the beneficial ownership rule, new requirements mandate that many companies doing business in the United States securely report basic information to the U.S. government about who really owns and controls them, also known as beneficial ownership information. This framework is an important step in stopping the flow of illicit funds that hurt law-abiding small businesses, as well as protecting our economic and national security from bad actors. Starting January 1, 2024, companies that fall under the beneficial ownership reporting requirement must file certain information about their beneficial owners with the Financial Crimes Enforcement Network, also known as FinCEN, the bureau in the U.S. Treasury Department that is leading this effort. FinCEN is an office that protects the U.S. financial system by supporting law enforcement and implementing anti-money laundering regulations. The beneficial ownership reporting process is safe, simple, and secure, and FinCEN will only share this information with authorized recipients for the specified intent of supporting federal, state, and local law enforcement, defending U.S. national...
So that's a thing. Only with authorized participants, right? So the question is, will this information be available to maybe a plaintiff's attorney that wants to sue somebody, right? They say it won't, but there's an end run around that, okay? So it basically has now lifted a lot of the opportunity to have asset protection, which the first step toward asset protection is privacy. That's step number one, right? Not letting the whole world know how rich you are. If you're listening to this show, you're probably doing pretty well, right? So this is you we're talking to. All right, let's keep going.
And safeguarding the integrity of our economic...
By the way, I sped this up a little bit just so you don't get a cure for insomnia listening to the show.
At fincen.gov/BOI, you'll find all the resources you'll need to comply. Starting January 1, 2024, you'll also be able to report your beneficial ownership information on this website.
Able to.
Today, we'll walk through the basics of the reporting
have
requirements. The Small Entity Compliance Guide, available at fincen.gov/BOI, contains answers to many key questions about the reporting process, including which companies are required to file, as well as what, when, and how to report beneficial ownership information. We'll start with the foundational question. Is my company a reporting company? In other words, does my company have to report its beneficial owners? Reporting companies can be domestic or foreign. The key question is whether this entity was required to file a document with a Secretary of State or similar office when it was created, or whether it was registered to do business in the United States. If yes, then the company might be a reporting company. I say might be because there are 23 exemptions for entities like banks, credit unions, tax-exempt entities, public utilities, and certain large companies.
In other words, the people that lobby Congress and pay them off.
Help you determine if an exemption applies. Okay, so let's say you had to file a document with the Secretary of State or similar office to create or register your entity, and you determine that none of the 23 exemptions applies. The next step is to figure out who your company's beneficial owners are so you can file the report with FinCEN. A beneficial owner is any individual who directly or indirectly owns or controls at least 25% of the ownership interests of a reporting company, or exercises substantial control over a reporting company. An individual can be a beneficial owner by virtue of both ownership interests and substantial control, or simply by one. I should note that there are several exemptions to the definition of beneficial owner. Reporting requirements may look a bit different for minors, nominees, intermediaries, custodians, or agents, employees, inheritors, or creditors. Again, the Small Entity Compliance Guide has checklists and other tools to help answer any questions you might have about these topics. Let's talk about ownership interests. Reporting companies are required to report all individuals who own or control at least 25% of the ownership interests of the company. Ownership interest is fairly broad. It encompasses stocks and equities, capital or profit interests, convertible instruments, options or privileges, and any other instrument, contract, or mechanism used to establish ownership in a company. Now let's talk about substantial control. Companies are required to report as beneficial owners anyone who meets any of the following criteria. 1. The company's senior officers. 2. Individuals who have the authority to appoint or remove senior officers, or the majority of the board of directors. 3. Important decision makers. And 4. Individuals who have any other form
important decision makers. Do you see how they left that so vague? So they can basically come after anybody with the fine or the jail time.
It is better to err on the side of over-reporting rather than run the risk of under-reporting. We'll talk about what company applicants are in a moment, but first, let's review which companies are required to report this information.
Okay,
If
here
a
you
reporting
go.
company was created or registered before Jan 1, 2024, then it is only required to report its beneficial owners, not its company applicants. If a company was created or registered on or after January 1, 2024, then it is required to report its company applicants along with its beneficial owners.
So for those of you who
Company
already
applicants can be up to
registered your
2
companies,
individuals.
good news for
The
you.
first is the individual who directly filed with the Secretary of State or similar office to create or register the company. The second is the individual who is primarily responsible for directing or controlling the filing of that document. Sometimes these might be the same person, as when a business founder does everything themselves, and sometimes these are 2 different people, as when a senior attorney directs a junior attorney to handle the creation or registration filing. In this case, both the senior attorney and the junior attorney would be considered company applicants. Now that we have a basic understanding of reporting companies, beneficial owners, and company applicants, let's get into the actual information companies need to report. First, you'll need to report some information about the company itself, including the company's legal name, any trade name or any doing business as name, the company's complete U.S. address, the state, tribal, or foreign jurisdiction of formation, and the company's taxpayer identification number or foreign tax ID. For foreign reporting companies, we'll also need the state or tribal jurisdiction of first registration.
So in other words, even if you're on an Indian nation,
for each beneficial owner and company applicant,
that's what
you
it
need to
looks
submit
like.
just 4 pieces of information: full name, date of birth, address, and the identifying number and issuer from a non-expired driver's license or passport, or an identification document issued by a state government, a local government, or an Indian tribe.
This
If
is
none of
going
these
to
documents
be
exist, you can use a foreign passport.
just
Please note you'll also need to submit an image of the
haven,
document. There are instances when,
an
instead of reporting
opportunity
the 4
for
pieces of
identity
information
theft.
required for a beneficial owner or company applicant, a company can report a FinCEN identifier. A FinCEN identifier is a unique number that FinCEN will issue upon request after directly receiving the required information from an individual or entity. Although there is no...
Now you're going to have another number. You already have Social Security, passport number, driver's license number, and a bunch of tax ID numbers, for each entity, right? So now there's a new number. There's a new number to keep track of you.
requirement to obtain a FinCEN identifier. Doing so can simplify the reporting process and allows entities or individuals to provide the required identifying information directly to FinCEN. FinCEN identifiers will not be available until January 1, 2024, when the reporting requirements take effect. Please refer to the Small Entity Compliance Guide for more information on how to apply for a FinCEN identifier.
Just wait up, please.
Let's talk about when you need to file. Companies created or registered to do business in the United States before January 1, 2024 must submit their initial beneficial ownership information reports to FinCEN by January 1, 2025. However, if you've newly created or registered a company on or after January 1, 2024, you must report your beneficial ownership information within 90 calendar days of receiving actual or public notice, whichever comes first, that the company's creation or registration is effective. Beginning January 1, 2024, companies will be able to report their beneficial ownership information directly to FinCEN using a secure electronic filing system. All right, so your company filed its initial report, but something changes and now the information you submitted to FinCEN is outdated. Maybe a beneficial ownership sold all their shares or the company moved. You'll have 30 days after the change occurs to update your report. You can do this by going to the same website where you filed your report. This is where it's going to be
just a
There may be
massive
instances
hassle.
where you need to correct a report. Once a company becomes aware of or has reason to know of an inaccuracy, it's required to correct the report within 30 days. So for example, if you filed your report and later realized you made a typo, you have 30 days to correct that report. Just as before, you can do this by going to the same website where you filed your report, fincen.gov/BOI. The question comes up, what if my company doesn't report beneficial ownership information within the required timeframe? FinCEN understands that this is a new requirement, and we're working hard to raise awareness about it and help companies comply. We also understand that new requirements take time to get used to. If a company makes a mistake in a report but corrects it within 90 days of the deadline for the original report, the company may avoid penalties. However, willfully failing to report complete or updated beneficial ownership information can carry significant civil and criminal penalties.
And they are
We're here to minimize
significant.
confusion and support companies as they navigate these new transparency requirements. FinCEN has been closely monitoring comments and inquiries on the reporting process and developing resources in response.
All right, so there you go, folks. Now, let's get to the guide. You can download this guide from the FinCEN website, and it's 57 pages to help cure your insomnia. I'm sure you can't wait to read this 57-page guide, right? So basically, it goes into beneficial ownership, and I love it. I'm going to get to the part where who they exempted from this, the 23 exemptions. You're just going to love this. So here they are. Section 1.2, is my company exempt from the reporting requirements? Who's exempt? You might as well just look at a list of the lobbyists, right? Who's lobbying Congress, right? That's who's exempt. So securities reporting issuer, government authority, banks, credit unions, depository institution holding companies, money services business. Now, I don't know exactly what that means. Is that like Western Union or what is that? But wouldn't you think that would, like, these are literally the places where the money laundering occurs, right? but they're exempt. Okay, so yeah, securities exchange or clearing agency, broker or dealer in securities, other Exchange Act registered entity, investment company or investment advisor. Oh, maybe. Okay. Yeah, that's interesting. Venture capital fund advisor, insurance company, state licensed insurance producer, commodity exchange, accounting firm, public utility, financial market utility, pooled investment vehicles. So they don't have to report. Okay, so let me see. If you're a money launderer and you set up one of these types of companies, it'll be easier for you. Okay, yeah. Tax exempt entities, so charities. Entity assisting a tax exempt entity. So I guess you could be a consultant for nonprofits, right? Or something like that. Large operating company. Okay, so Apple and Google, they're not going to have to comply. Okay, subsidiary of certain exempt entities. What does that mean? There will be a whole complicated body of law, or an inactive entity, right? So can you just see all the holes in this and all of the compliance headaches and nightmares? And by the way, the penalties are enormous for not complying with this. They are insane. They are insane how high the penalties are. But anyway, this 57-page guide is available for your reading enjoyment. I haven't read it. I'm not going to have time to read it, but I'm going to pay our attorney $200 for each of my entities to go ahead and just handle this reporting requirement. And I suggest you do the same. If you need a referral, just reach out through jasonhartman.com, just any one of the contact forms on our website, and we'll be happy to connect you with our attorney that'll do this for $200 per entity. Anyway, that is the Corporate Transparency Act. And as with every year, there are a whole host of new laws, regulations, and requirements. So be sure you are in compliance. And I don't mean regarding this, I'm just talking about laws and regs in general, especially if you live in a heavy government state like California, New York, etc. If you live in the freer states, then you don't have this problem so much. But there it is, the Corporate Transparency Act in a nutshell. I hope that was helpful. Please be sure to comment below with any questions or comments you have. We'll try and address those in a future video for you. And thank you again for listening. Happy investing and Happy New Year.